Purely arbitrary laws are purely unjust laws. Viva Frei, Montreal litigator turned YouTuber, taking a break from the holiday love and noise, but mostly the noise, to do this vlog because when I heard that Angela Marsden was suing Gavin Newsom, I had to do a vlog on it. Now, for those of you who may not know, relatively recently a video went viral, I think at first on Facebook and then everywhere, of one Angela Marsden, the owner of Pineapple Hill Saloon and Grill, making a video about how she was effectively shut down by Gavin Newsom's executive orders, while right next door to her, at the same time, a movie studio set up an outdoor dining salon, whereas she was just shut down outright. The video went viral, as viral videos tend to do, because it tapped into something of a universal human emotion, and in this case it was anger and frustration at a government that doesn't seem to know what it is doing, and while it is crushing certain people, it is handing out freebies to others. If you haven't seen the video, I'm only going to show you a few seconds of it right now, but I'll put in a link so that you can watch it for yourself. It is absolutely heartbreaking and frustrating to watch.
Everything I own is being taken away from me, and they set up a movie company right next to my outdoor patio, which is right over here. They have not given us money and they have shut us down. We cannot survive. My staff cannot survive. Look at this. Tell me that this is dangerous, but right next to me as a slap in my face, that's safe.
Well, it seems that Angela Marsden is not only taking her fight to social media, she is taking her fight to the courts, because she has filed suit against Gavin Newsom and others to avail herself of her rights for what is obviously, on its face, an outright injustice. This lawsuit really closely resembles all of the other COVID-related lawsuits that we have gone over on this channel, in that they are attacking government laws on the basis that they are totally arbitrary, totally unfounded in science, and seem to grant certain people preferential treatment over others. So with that said, and because I have limited time until the kids actually get bored of playing Contra without me, let's go over the highlights of the lawsuit so you can know what is going on, and so that you can share this video around so the rest of the world knows what is going on in California and elsewhere. United States District Court for the Central District of California, Calm Ventures LLC, a California limited liability company doing business as Pineapple Hill Saloon and Grill, plaintiff. Complaint for declaratory and injunctive relief. We have seen this before. A complaint for declaratory relief is a complaint to the court to declare that someone's rights have been violated. A complaint for injunctive relief is a complaint to the court to enjoin the defendant from violating the plaintiff's rights. And in plainer English, that is a complaint to the court asking the court to tell the defendants to stop violating the plaintiff's rights. Versus Gavin Newsom in his official capacity as Governor of California, Xavier Becerra in his official capacity as the Attorney General of California, Eric S. Pan, MD, MPH, in her official capacity as the Acting State Public Health Officer for the California Department of Public Health, State of California Health and Human Services Agency. Defendants. This is a very well-drafted lawsuit by Harmeet Dillon and Mark Garagos in particular, and it starts off with a very powerful excerpt from the Great Barrington Declaration, which reads as follows. Current lockdown policies are producing devastating effects on short and long-term public health. The results, to name a few, include lower childhood vaccination rates, worsening cardiovascular disease outcomes, fewer cancer screenings, and deteriorating mental health, leading to greater excess mortality in years to come, with the working class and younger members of society carrying the heaviest burden. The most compassionate approach that balances the risks and benefits of reaching herd immunity is to allow those who are at minimal risk of death to live their lives normally, to build up immunity to the virus through natural infection, while better protecting those who are at higher risk. We call this focused protection. Those who are not vulnerable should immediately be allowed to resume life as normal. The Great Barrington Declaration, signed by over 51,970 medical and public health scientists and medical practitioners from around the world and across political ideologies. At its core, it is a very basic lawsuit. California basically issues executive orders. It says that certain businesses are essential businesses while others are not, and those that are not essential businesses cannot operate, basically. But not only that, even among the businesses that are declared non-essential businesses, somehow others with more political influence and deeper pockets seem to find themselves being put in exceptions. Plaintiff is a restaurant located in Los Angeles County. As a result of defendants' executive orders and public health orders, plaintiff has been unable to fully utilize its leased property by serving dining opportunities to the general public. However, just 20 feet away, a major Hollywood production was recently in full operation, where it had an outdoor tent set up and was permitted to serve meals to its team of employees and contractors. Defendants, in a gross abuse of their power, have seized the coronavirus coronavirus pandemic to expand their authority by unprecedented lengths, depriving plaintiff and all other similarly situated small business owners in California of fundamental rights protected by the U.S. and California constitutions, including freedom of assembly and due process and equal protection under the law. It is this court's duty to defend these constitutional principles by safeguarding the many rights and liberties of Californians such as plaintiff that defendants so brazenly, arbitrarily, and capriciously violate. The lawsuit then goes on to describe the 4 executive orders at issue, collectively referring to them as the executive orders. We don't need to get into them individually, except to say that they seem to be relatively arbitrary, totally capricious, one contradicts the others, and plaintiffs have invested money into their businesses to comply with certain executive orders that seem to get overridden by others at a drop of a hat. The executive orders are totally arbitrary, totally capricious, seem to be totally unfounded in any form of science, and they violate the fundamental liberties of the plaintiff. The regional orders and defendants' enforcement thereof violate 1. The Freedom of Assembly Clause of the First Amendment, 2. Substantive rights protected by the Due Process Clause of the 5th and 14th Amendments, and 3. The Equal Protection Clause of the 14th Amendment. The executive orders and defendants' enforcement thereof violate substantive and procedural rights protected by the Due Process Clauses of the 5th and 14th Amendment. The lawsuit then goes on to describe the parties. We know who the defendants are, just to briefly summarize who is the plaintiff. At all relevant times, Plaintiff Com Ventures LLC, doing business as Pineapple Hill Saloon and Grill, Plaintiff or Pineapple Grill, is and was a limited liability company organized and authorized to do business and doing business in the state of California. Plaintiff owns, operates, and or manages an old-fashioned, dimly lit, quiet restaurant and bar with a fireplace that serves simple American-inspired fare, located at the heart of Sherman Oaks Square at 4454 Van Nuys Boulevard, North Sherman Oaks, California 91403. At all relevant times, Plaintiff has complied with existing local and state orders relating to the statewide effort to curb the spread of COVID-19, and in doing so has invested considerable time and resources into ensuring a safe and secure CDC-compliant workplace for its employees and patrons, including mandatory mask-wearing, socially distanced outdoor dining, sanitized surfaces after each patron use, and temperature checks for employees. The lawsuit then goes on to allege how Gavin Newsom, through various orders, declared certain businesses essential businesses and others not, and those that were not declared essential businesses were effectively ordered to shut down entirely. As a result of the issuance of Newsom's order, California businesses such as plaintiffs, which were not part of the 16, quote, critical infrastructure sectors, end quote, described above, were therefore deemed, quote, non-essential businesses and effectively ordered under penalty of fine and imprisonment to shut down. Without getting into the weeds of the allegations, the lawsuit effectively just goes on to say how these orders seem to change from one month to the next, and the plaintiff, who invested sums of money to be compliant with the older orders, sees new orders come into effect that shut her down nonetheless, and she's basically just wasted all that money trying to comply with the orders in the first place. On May 7, 2020, State Public Health Officer Dr. Angel issued an order permitting the gradual reopening of businesses and activities in California in stages. The order provided for 4 stages of gradual reopening, with the final stage, stage 4, consisting of an end to all stay-at-home orders and a full reopening of businesses. As a result, on or about the beginning of June 2020, plaintiff's business reopened for indoor dining, but was only allowed to do so at 50% capacity. Thereafter, and on July 13, 2020, the State Public Health Officer issued a further order directing all restaurants in the state of California, such as plaintiffs, to again cease indoor dining service. The order applied to all restaurants regardless of ICU bed capacity, availability, or the number of deaths experienced in each county. As a result of the July 13, 2020 order, plaintiff was also unable to recoup the costs of implementing the safety measures imposed by the May 7, 2020 order as a condition to offering indoor dining to their customers. On August 28, 2020, defendant Dr. Pan implemented a statewide order that abandoned the previous staged reopening plan promulgated in the May 7, 2020 order and dictated that counties would be classified according to a new plan entitled, quote, Blueprint for a Safer Economy, end quote, under which a color-coded, quote, tier system would be used. Under this new color-coded tiered system, each California county is placed in one of 4 tiers: purple, red, orange, and yellow, ranging from the most to least restrictive, respectively. Unlike the previous staged reopening plan under the May 7, 2020 order, the current, quote, tier system under the August 28, 2020 order does not provide any criteria under which California's businesses and economy would be permitted to fully reopen. We are going through the same thing in Canada. We have government creating measures that the restaurants have to comply with. They invest substantial sums of money to be compliant with the already arbitrary measures put into effect by the government, only to see the government change those measures and they've basically lost their investment altogether. Arbitrary, capricious, unjust, but it gets even worse. Specifically, the state of California did not initially include Hollywood studios in the list of, quote, essential workers issued in March 2020, but a revised listing issued in April 2020 declared that workers involved in, quote, the entertainment industries, studios, and other related establishments, end quote, to be essential, quote, provided they follow COVID-19 public health guidance around physical distancing, end quote. Now, here's a pretty obvious question. Why wouldn't all businesses be deemed to be essential businesses if they followed COVID-19 safety protocol? If one were to succumb to cynicism, it would seem that who is determined to be an essential business has actually less to do with actual risk and more to do with how deep your pockets are. So while Hollywood studios were not initially declared to be essential workers, that situation changes, and I wonder why that situation changed. Then, in November 2020, Newsom provided a special exemption to television and film production companies for his earlier limited shelter-in-place order issued before Thanksgiving, which featured a curfew from 10 p.m. to 5 a.m. The workforce on film sets could continue operations throughout the night. Earlier in December 2020, a central coronavirus testing site at the Union Station building faced a temporary closure to accommodate the filming of a remake of, quote, She's All That, featuring TikTok star Addison Rae. Some 500 appointments were cancelled. The negative news cycle resulted in an intervention from the mayor's office to keep the testing site open. It's all about safety. Nobody is getting any preferential treatment, right? Then we get into the allegation about the video that went viral, which reads as follows. Around the same time, plaintiff's principal Angela Marsden posted a video just after her establishment's outdoor dining area had been shut down by virtue of defendant's regional orders. Ms. Marsden's video went viral. In her video, Ms. Marsden displays the hypocrisy, lunacy, and total disparity between her own socially distanced outdoor setup at her establishment juxtaposed by a similarly situated setup containing outdoor tents and chairs associated with the NBC Universal production set for the series, quote, Good Girls, which was allowed to proceed as essential work. The disparity in exemptions, such as described herein, is causally related to the state officials, such as Newsom, supporting their campaign donors at the expense of small businesses and has nothing to do with science and data. And because it is not only a bad fact, but the most stunning display of government hypocrisy, you knew the plaintiff was going to allege it somewhere. The plaintiff goes and talks about how Gavin Newsom went out for dinner at a lavish restaurant while he was shutting everyone else down. On November 6, 2020, Newsom attended the infamous dinner at French Laundry for Jason Kinney's birthday, in which the bar tab reached $15,000. And dinners started at $310. Jason Kinney is a lobbyist whose biggest client is Netflix, which has been allowed to operate during the latest round of forced closures as intensive care hospital capacity has dwindled across the state. It is no secret that Hollywood lobbyists and insiders have leveraged their industry's economic and political contributions to the state's political power brokers and Democratic machine in order to insulate it from COVID-19 related regulations. To highlight this issue, just Netflix's quarterly lobbying spending alone nearly tripled as it jumped from $24,437 to $70,725 a quarter. The jump in spending includes increased fees to Axiom Advisors, the firm founded by Kinney. Further, the, quote, Big Six production studios have donated heavily to elected officials and campaigns across California. Netflix and its employees gave $135,950. Walt Disney and Company and its employees gave $183,999. Paramount and its employees gave $119,308. Sony and its employees gave $27,961. Comcast, NBC Universal and its employees gave $251,588. And Warner Brothers and its employees gave $77,050. The campaign donations were spent as the firms also deployed lobbyists to shape the pandemic rules governing the entertainment industry. If that doesn't enrage you, nothing will enrage you. Those are the facts in a nutshell. Absolutely arbitrary government rules which are crushing the working class, but somehow those who are well connected and have deep pockets seem to find exceptions notwithstanding alleged safety issues. This is the world in which we live, and I've got to tell you, it is arbitrary, it is unjust, and it is totally corrupt. The lawsuit then goes over the claims for relief, which we'll go over very briefly because I can get that spider sense tingling when it's time for me to go back to the house. First claim for relief, violation of First Amendment Freedom of Assembly Clause. 42 U.S.C. Section 1983. The right of free speech, the right to teach, and the right of assembly are, of course, fundamental rights. When a government practice restricts fundamental rights, it is subject to, quote, strict scrutiny, end quote, and can be justified only if it furthers a compelling government purpose, and even then, only if no less restrictive restrictive alternative is available. Second claim for relief. Due process clauses of 5th and 14th Amendments to U.S. Constitution. 42 U.S.C. Section 1983. Pursuant to 42 U.S.C. Section 1983 and 1988, plaintiff is entitled to declaratory relief and temporary, preliminary, and permanent injunctive relief invalidating and restraining enforcement of the regional orders. Third claim for relief, Equal Protection Clause of 14th Amendment to U.S. Constitution. Fourth claim for relief, Due Process Clause of 5th and 14th Amendment to U.S. Constitution. The Due Process Clause of the 14th Amendment provides in pertinent part that, quote, no state shall deprive any person of life, liberty, or property without due process of law. The Due Process Clause of the 5th Amendment provides in pertinent part that, quote, no person shall be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. As set forth herein, defendants' executive orders have unlawfully violated plaintiffs' procedural due process rights by delegating authority to an unelected, appointed bureaucrat who is exercising this power to deprive plaintiff from being able to operate its lawful businesses at all. Procedural due process, quote, protects rights created by state law and guarantees that no significant deprivation of life, liberty, or property will take place until notice has been provided and the individual has a meaningful opportunity to be heard, end quote. So that is the lawsuit, and given recent decisions that have come out of the states, I'm cautiously optimistic that the plaintiff may actually succeed on this claim, but I am also sufficiently concerned that the relief may come too late and that the damage has already been done. People's lives and livelihoods are being crushed to the point of being unsalvageable as a result of these arbitrary, capricious, and totally unscientific regulations in the first place. And while the working class and people who are not connected are being crushed, those who are connected and those with deep pockets who can line the pockets of the politicians are finding exceptions under the law. And even as I sit here in my car in Canada talking at you through my camera, and I don't know if you can hear the sound of the geese flying overhead, but they were actually flying overhead, I had a solution to the problem. Gavin Newsom, here's an idea. Why didn't NBC Universal actually just rent the facility from the plaintiff? Instead of setting up shop in front of her place that you just shut down, why not have the studios actually rent the Pineapple Hill Saloon? Why not find solutions that actually help the people as opposed to help certain special interests? But I think we all know the answer to that question. And with that said, if you like my videos, you like my content, please be sure to like, share, subscribe, hit the notification bell, and drop a comment in the comment section below because it feeds the algorithm. If you want to support the channel, all of these support links are in the pinned comment, but more important than that, support yourself, support your friends and family, support your community, make sure everyone around you is doing well. Happy holidays, Merry Christmas, Happy New Year, and may we have a better 2021, and now you know your vlog. Peace out.